On this week's episode of the Crushing Debt Podcast, judgment liens and property.
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner with Yesner Law. And like you heard at the beginning of the episode, this episode is dedicated to judgment liens and whether or not they attach to real property. Now, the thought process behind this episode came from the blog. And two of the most searched articles that I have on the Yesner Law blog, one is whether judgment liens attach to inherited property, and the other one is the notice of homestead procedure. Now, some of you might recall that a few weeks ago I talked about inherited IRAs, and I know that the law of the land is that inherited IRAs are not exempt, and so therefore a judgment lien could attach to an inherited IRA. In other words, mom or dad passes away, they have an IRA, they leave you with that IRA. That IRA is not exempt from creditors. Creditors could get at that inherited IRA to pay creditor claims. Certainly the trustee, the bankruptcy trustee, if you were to file bankruptcy, could get at that IRA to pay creditors' claims. But what I wanted to talk to you about generally were judgment liens attaching to inherited property, and then the notice of homestead procedure. Well, before I get there, let me talk to you about our sponsor. So our sponsor is Elliott Wealth Management Services. They provide life insurance and life insurance products. So I do encourage you to go to their website, which is elliottwealth.com. Up in the right-hand corner, there should be a free life insurance assessment button. If you have anyone that relies on your income, for example, if you are a real estate investor, what would happen to your portfolio if something would happen to you? Is there enough money within the portfolio to run the portfolio for the benefit of your heirs? If the answer to that is no, then definitely go to elliottwealth.com, click on the life insurance assessment button, and talk to Chris Calandra and his team about whether life insurance would be a good fit for you. Given that scenario, I absolutely think it would be. So back to judgment liens and inherited property. So here's how it works in the state of Florida. There are a handful of requirements in order for a judgment lien to attach to property. First of all, the judgment lien has to be a certified recorded copy of the judgment lien. So a lot of times what judgment creditors will do is they will record the lien in the public records. Once they get their judgment, they record the lien in the public records. They then get the clerk of the court to issue a certified copy. So the clerk will put a stamp on that recorded document, in this case the judgment lien, to say this is a certified copy of the judgment lien that exists within the public records. You then record that judgment lien. So if you're looking at a judgment lien to see if it attaches, you want to look for a couple things. You want to look for 2 recording dates. And then on the one that has the 2 recording dates, the second time it's recorded, you want to make sure there's some stamp certification by the clerk of the court at the bottom of the document. If you have those 2 things, that it's recorded twice, and you have that there is a clerk certification on the bottom of the or somewhere on the document, now you have a certified recorded copy of the judgment. Potentially it attaches. Another requirement of that judgment attaching is that it has to have the creditor's address on it. Now, a lot of times the attorneys will say, creditor care of attorney XYZ law firm. That's incorrect. It's got to have the creditor's address on it. So it's got to say creditor, 123 Main Street in such and such city, state, zip. And then if it also wants to say care of attorney whose address is blank, that's okay. But the judgment has to have the creditor's address on it. Another thing that the judgment has to have under Florida law, it's got to be at least 10 years old or younger than 10 years old. It has to have been recorded within the last 10 years. Now, if the judgment gets to the end of the first 10-year period, it can be renewed for another 10 years. So a judgment recorded in, as I record this, it's 2019. A judgment recorded in 2015 would be good until 2025. A judgment recorded in 2005 that is recorded in 2015 would be good in 2025 and not beyond that. A judgment that's recorded in 1995 and renews in 2005 would expire in 2015. So now as we would look at that judgment in 2019, it has expired and we don't have to look at it. Now, the maximum statute of limitations on a recorded judgment is 20 years. So I don't think we would necessarily run into a lot of this too often, but that time period has changed as time has gone on. So you have to look at when that judgment was originally recorded and then what timelines were in place when that judgment was originally recorded. You have to do an analysis. There is something out there called the Knox paradigm. And what the Knox paradigm will do is it'll run you through the Knox judgment paradigm. Will run you through all those time periods, and it's just simple yes or no questions. And then if you answer yes to all the questions, it is a lien. If you answer no to some of the questions, it'll print out that it is not a lien. But also you should have an attorney review it. That's a way to tell if the document is still a lien or not. So it has to have certain of those indicia. It has to be less than 20 years old. It has to be recorded in the last 10 years or renewed in the last 10 years. A certified recorded copy of the judgment has to be recorded, and the judgment has to have the creditor's address on it. If that is true, then that judgment attaches to all non-homestead property in the county where it is recorded. So if the judgment creditor owns property in Hillsborough County, but the judgment is recorded in Leon County or Alachua County or Broward County, it would not attach to the property owned in Hillsborough County. That judgment would have to be recorded in Hillsborough County in order to attach to property in Hillsborough County. So a lot of times what you will also see is the judgment creditor record that judgment in every county that they think the debtor, the person who's responsible for paying back the debt, any county where that person owns property, the judgment would be recorded, and therefore it would attach to all those properties. Now, I've said non-homestead property a few times. If the property is homestead, here's what I think. Technically, the judgment attaches, even though it is homestead property, and even though Florida law says homestead property is exempt, the judgment technically attaches. And like I wrote in a previous blog about the notice of homestead procedure, Florida has a procedure. If I sign an affidavit that says that this property is my homestead, and I provide my attorney or my title agent or whoever with enough record documents to show that the property is my homestead, documents like driver's license, voter registration, electricity bill, utility bill, car registration, where other bills go, all the different indicia that this is the primary residence. And then I file a notice of homestead affidavit in the county where the judgment is recorded. That judgment will cease to be a lien on the property, on the homestead property. It will remain a lien against non-homestead property, and the debt will remain. So if I have a $50,000 judgment against me, but I file a notice of homestead because I want to sell or refinance my house, that $50,000 is no longer a lien against my house for the purposes of that sale or for the purposes of that refinance. But I still owe the $50,000 theoretically. So the notice of homestead procedure is a procedure to remove the lien from the house. Now, typically the way that it works is I submit my affidavit and my documents to the clerk of the court. The judgment creditor has to get notice, which I think is one of the reasons the judgment creditor has to have their address on the judgment so that they can get the proper notice. But I file my documents, my notice of homestead in the clerk of the court. The clerk of the court will record that in the public records to give everybody notice. And then the clerk of the court will send out a certified return receipt envelope to the creditor at the address on the creditor judgment, or if the creditor has updated the judgment or updated any of the addresses or whatnot, that's where the certified letter will go. The judgment creditor then has 45 days to dispute that this property is not my homestead. If they do dispute it, then we have a hearing in front of the judge, and I have to prove that it is my homestead, and they bring whatever documents to prove it is not homestead. If they do nothing within that 45 days, the lien is automatically eliminated for that closing. So, for example, if I decide that I'm going to refinance this year, and I have a judgment against me, and I do the notice of homestead, and it is my homestead property, the lien comes off. If I want to refinance 10 years from now, I have to go through the notice of homestead procedure again. And the logic behind that's fairly simple. I mean, how does the creditor know that I haven't moved out and turned it into non-homestead property in the last 10 years? So I would have to do another notice of homestead to give the creditor notice. Now, why might the creditor object if the creditor thinks the property's not your homestead? If the creditor thinks you don't live there, if you don't get mail there, if that's not what your driver's license says, if that's not what your voter ID says, all the different indicia of homestead. Did you register for the homestead exemption when you bought the house, when you moved into the house? All the different indicia that this property is your homestead. I do remember doing a podcast episode years ago called the Florida Homestead Exemption versus the Homestead Exemption in Florida. And I'm trying to pull that up for you here now to tell you what podcast number it is. Looks like it is episode 15, way back at the beginning of the podcast. Episode 15 talks about the Florida Homestead Exemption, and then episode 104 talks about property tax portability. So when you move from one homestead to another, you can actually take some or all of that homestead exemption, some of that homestead benefit with you from the old house to the new house. So, again, if you want to check those episodes out, episode 15 and episode 104 also deal with the homestead exemption. But it is a factual analysis. So what are the facts that determine whether this property is my homestead? And if it is, then I can eliminate that judgment lien from the property and I can still perform the closing. So here's the issue with inherited properties. And this happens a lot when we have people that want to add sons or daughters to property. So mom and dad are getting up there in age and they say, we want to add our son or our daughter to our house so that in the event something happens to us, son or daughter will be able to keep the house. That is a good idea, but simply adding the son or daughter to title is the wrong way to do that, because let's assume that son gets into some financial trouble and doesn't pay his Visa card, and Visa gets a judgment against him. And then mom and dad add son to the title of the house, and Visa records that judgment in the county. Now that Visa judgment attaches to the son's half of mom and dad's house. Or let's assume that mom and dad add son to the title of their house in the event something happens to them, and then somewhere down the road, son and daughter-in-law get divorced, and the judge puts a lien on all of son's property because he needs to pay the daughter something through the marriage. Well, again, that lien then attaches to mom and dad's house because they've added the son to the title. Now, one way around that is something called a life estate deed or an enhanced life estate deed. So mom and dad own the property for their life, and when they die, the title goes to their son. And then in that case, the son is not on title until mom and dad pass away. So if son gets a judgment against him, that judgment would not attach to the title to the property, at least at the beginning. If mom and dad then pass away and son inherits the property, the lien then pops on the property. Now, again, son could decide, I'm going to move into mom and dad's house and I'm going to take care of mom and dad's house because it was free and clear, for example. And so I'm going to sell my house and use that cash and then move into mom and dad's house that was free and clear, and now I own a free house. Well, again, that might be okay to do, and if the son were to do that, then the judgment lien would no longer be attached because the son would be living there and it would be the son's homestead property. And assuming mom and dad did the deed correctly, the deed would be entirely in son's name. There would be no probate required, and that would protect the property. But it's got to be some type of life estate deed, some type of ladybird life estate deed, some type of trust that protects the inheritance, something along those lines. So I would definitely suggest, if your mom and dad want to leave you with property, or aunt and uncle, or some family member, or some stranger wants to leave you with property, definitely talk to an attorney and talk about how that can be structured in such a way that if you should be responsible for paying back some debts, those debts would not attach to the property. And again, it may work the other way. Let's say, for example, that somebody is living in a house, but they need to move out, they need to move to another house, they need to downsize, and they are so enamored with this younger person for having helped them out that they give this younger person a title to their house. Well, the instant that they move out to go live somewhere else, the house no longer becomes their homestead. If they have a judgment against them, then now the person that has received the house receives it with that judgment lien still in place because it was not the grantor's homestead anymore when the grantor moves to another property. Now, that's a very specific fact pattern, and I think the creditor would have to prove that in a court. But still, it may be something that from a title insurance perspective, the people that are giving you title insurance policies on refinances, or the type of people that are giving you policies on sales of properties, may have an issue with that type of a fact pattern and may be hesitant to give you a title insurance policy under those circumstances. So just remember, if you are going to inherit property, or if you want to leave property to somebody, you should probably talk to either a real estate attorney, or probably better yet, an estate planning attorney, to determine what debts do I have? Is there anything out there that could create a judgment against me? What debt does my son or daughter or the person that I want to leave this property to, what type of debt do they have? And will that attach to the real property? And if you can do that analysis up front, you can avoid leaving a house and a creditor that has to be dealt with behind when you pass. So, short episode this week, but it was something that was gaining interest on the internet through the blog that I could see. And so I wanted to bring it to you in a podcast episode about judgment liens attaching to inherited property. And then obviously the notice of homestead procedure when the property is your homestead to remove those judgment liens. So that'll do it for this week's episode of the Crushing Debt Podcast. And I'd like to remind you that I hope that at the end of the month you have more money, and at the end of the money you don't have any more month. That's it for this week's episode of the Crushing Debt Podcast. I will talk to you in next week's episode.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.